Hey, Rick Chapo here with DMCA Agent Service.com. Just cutting a video today on yet another lawsuit that's been filed by the recording industry, in this case against an ISP. But it's the theory that's being used in the lawsuit that we want to focus on because we're seeing it used again and again. And in a lot of cases, it's being used successfully. So specifically, we're looking at record companies using a repeat infringer strategy to attack DMCA immunity. And in this case, the recording industry, the parties that we have involved are Sony, Universal, and Warner Brothers. And they are suing Charter Communications, which you might know better as Spectrum. And they are an ISP. So they're providing access to the internet for various groups of people. Now, the DMCA, of course, provides internet service providers such as Spectrum with immunity from copyright infringement claims based on content uploaded by users. So if we think about Facebook's usually the classic example. If I go out and I hear a song that I like and I burn a copy of it and I upload it to my Facebook page, well, that's copyright infringement. There's no fair use defense that I can think of for that, so I would be liable for copyright infringement. But what about Facebook? And the answer under the DMCA is Facebook would not be liable. Facebook did not upload the song. They just provided the platform, and they didn't really have any control over it. And so in that situation, they are immune. Now, to maintain this immunity, you have to follow a certain compliance process. Facebook would, any site or any ISP would, in this case, Spectrum. But even if you have a blog or an app or a website and you're allowing users to upload to it, you need to do this because you want to make sure that you have that immunity. And so part of the process is that you must establish a repeat infringer policy and you must enforce it. So what is a repeat infringer policy? It's pretty much exactly what it sounds like. You keep a spreadsheet of all your users who receive complaints. And if they receive X number of complaints within X period of time, you must terminate them. You must block them from using your site. So if you have a troll out there, copyright troll, who is just posting infringing material right and left, the idea is that this element of the compliance process will essentially force them off the site and get them to stop such activity. Now, whether that actually will work is up to debate because they can, of course, always go to another site or open another account under another name and so on and so forth. But nonetheless, that's the basic idea. And where we're seeing record companies and other parties attacking websites and apps and ISPs is they are arguing that either you do not have a repeat infringer policy or it's not being enforced. And it's this second element where we're seeing some real success. So in this case, the argument is that Charter Communications knows that there's been infringement. They've received DMCA takedown notices, and they just haven't enforced their repeat infringer policy. So they have users who may have, who knows, dozens of complaints, hundreds of complaints, and should have been terminated, but Charter didn't do that. And if the court finds that that is in fact the case based on the evidence, well, the likely ruling is Charter has waived its immunity under the DMCA. It would then be held liable, potentially liable, for the actions of its users. Now, you can imagine Spectrum probably has millions of users, and some percentage of those users have uploaded music without consent or a license. And so it could be a pretty ugly situation, to say the least. Now, we don't know the outcome. The lawsuit was just filed, but it'll be interesting to see how it plays out. However, we do have a recent example where things have moved along a little bit farther, and that was a case involving Grande Communications. If you go to our page here on YouTube, you can see a video on it under cases, the cases playlist. But basically what happened was Grande Communications is an ISP in Texas, and same allegations were made. They had a repeat infringer policy, and they weren't enforcing it. And once evidence was produced in the case and looked at, it became fairly clear that that was true, that they had a repeat infringer policy and they had been enforcing it up to 2010. And then from 2010 to 2016, it appears as though they didn't enforce it at all. At least that's certainly the allegation, and that's what the trial court found. And so in that situation, the court ruled that Grande Communications had waived its immunity under the DMCA. and it can be found jointly liable for copyright infringement for all the potential infringing acts of its users. So that was a bad day for Grande Communications. As far as I know, the trial hasn't actually started yet, so I don't know that there's any actual finding of damages, or maybe a settlement happened, or who knows. But all in all, that's something you don't want to run into. So the lesson here is that when you're complying with the DMCA, 1, make sure you understand what all the compliance steps are. 2, make sure you set a repeat infringer policy. 3, make sure you enforce it and that you keep records of enforcement. Very important. You want to be able to show the court, hey, yes, we had this policy, and here are the records showing that we enforced it over the years. And it doesn't matter if you are the size of Facebook or you're a tiny little blog, that allows people to post comments. If you allow any user-generated content on your site or your app, make sure to comply with the DMCA and take all the compliance steps so you get immunity. It's free immunity. It's a beautiful thing. Take advantage of it. So that's it for today's video. If you enjoyed it, feel free to give us a thumbs up below. If you have any questions, feel free to post them. Thanks for watching. Have yourself a good one.